Welcome back to On the Beat, everyone. Isaac here again this week, and the last few weeks we've had Will Cooper from Crowell Gillis and Cooper talking a bit more about specific kinds of law that you practice in lawsuits. But today we're going to talk about just a plain old-fashioned lawsuit.
Right.
So if somebody decides they're going to sue somebody over something, kind of the grand scheme of things of a lawsuit.
How it all works.
Yeah, so how does one begin a lawsuit?
Well, first of all, you have to have what's called a cause of action.
Okay.
You have to have a reason to file a lawsuit.
Sure.
And when we talk about lawsuits, most people don't think in terms of the chancery side, the divorce stuff. They're thinking about personal injuries or suing someone because they breached a contract or they were wrongfully terminated or a product liability case or, whatever. They got run over by a car. Okay? And so those are what your typical lawsuits. And so those lawsuits always start with a complaint. Mm-hmm. But before that, as attorneys, we negotiate. And, usually a lot of times there's insurance companies involved. And we've talked in the past on the show about how to handle those insurance companies. But the negotiation process, i.e. to try to recover your damages, starts with negotiation, writing a demand letter, get together their medicals and photographs and all that and trying to settle it. But if we can't settle it, the first thing you do is file a complaint.
Okay, so the demand letter, who does that go to?
So the demand letter would demand letter, if you don't know who the insurance company is, you send it to the company. Okay. I mean, to the individual who was involved in the accident, for example. Okay. And then if they have an insurance company, they turn it over. But once we find out the name of that insurance company, we're negotiating with the insurance company.
Perfect. All right, so once the lawsuit or the complaint is filed and the lawsuit is coming to fruition, what happens next?
So then you have the discovery stage. Typically, the parties submit what's called written discovery, interrogatories, and requests for production of documents. Interrogatories are just a list of questions that you want to know from the other side. The defense asks the same type of questions. Requests for production of documents are exactly what it is. You're requesting documentation, medical records, accident reports, photographs, those kind of things.
Okay, I guess it's going to depend on what the complaint or lawsuit was.
Sure.
As to what questions.
As to what questions, right.
All right, gotcha.
And you need an attorney for that, of course, and you got an attorney because you filed a complaint.
Yes, so we're not in court yet, I guess, at this stage in the game. How long does all this take up to this point?
So the discovery, our uniform rules typically have a discovery deadline period. Okay. But what you do is you enter into a scheduling order, and that discovery deadline then is set forth in the scheduling order, and then you start taking what we call depositions, where you sit down with a court reporter and they ask your client or you ask the other side questions in a deposition.
Okay. And so, but we're still not in an actual full courtroom.
We hang on to trial yet.
Okay.
So in our district, prior to going to trial, our judges are going to order what's called a mediation, where then you go and you have a mediator, a neutral party. He sits down, he tries to resolve the case. And then, if it's unable to settle, you've got in that scheduling order a trial date. Okay. And that's when you finally get to a trial date in state court, and before a judge or a jury, remember? Sure. And so in state court, you can easily be looking at 2 years.
That's what I was going to say. How long? I mean, it goes from a couple of months upwards of 2 years.
Correct. And sometimes longer, don't get me wrong.
Sure.
It can be 2, 3, 4 years. In federal court, if you're in federal court where there's either a federal cause of action or what's called a non-citizen where they can remove it to federal court, then it typically goes faster because our federal judges have their finger on it more and they push it.
Sure. Okay. And then a last question. Everybody wants to know, how much does it cost?
Well, if you're the plaintiff, it's done typically on a contingency fee. You see these commercials, you don't get, I don't get a dime until you get a dollar.
Sure.
Really true. If you're on the defense side, though, and you don't have an insurance company, because your insurance company will pay the defense cost, if you don't have an insurance company, and then you're having to foot the bill, and that gets very expensive.
Very quick, especially if we're compounding over years and years, right?
Exactly.
Well, seemingly broad topic, but we could go on and on, but we're out of time this week. We sure appreciate your time.
Thank you for having me.
Additional questions, listed information there is at the bottom of your screen. We'll be back after this.